Do you ever feel like discussing plan giving is like navigating through a corn maze? The alphabet soup of options, tax law, probate, trusts, beneficiary designations can leave people spinning in circles. But much like a map will provide clarity to navigate through a corn maze, I'm here to be your map and your navigator through the world of plan giving. Today, we are going to discuss the topic of beneficiary designations with the hope of removing the mystery that often confuses people. Before we get started, I'm going to test your knowledge with two questions that often confuse people. The first question is, a person's last will and testament always controls the distribution of his or her estate. The answer to that is false. Question number two, Susie Donor, a longtime supporter of the Bon Secours Mercy Health Foundation, has one asset, a $5 million IRA. In her will, Susie leaves her entire estate to the foundation. However, Susie designated her favorite dog, Fido, as the sole beneficiary of her IRA when she opened the IRA. Who receives the IRA when she dies? Fido, the foundation, or C, it depends on whether Susie's will or beneficiary designation was signed more recently. The answer is A, Fido. Most people desire to direct where their assets will go following death. Perhaps it's their loved ones, their family. Maybe it's a favorite charity or their church. However, most people assume that the last will and testament is the document that's going to control where those assets will go. Historically, that was always the case, but recently there's been a variety of vehicles that have developed which allow assets to pass outside of probate. So now let's look at the different ways that assets can pass when a person passes away. The first way that assets will pass is through contract. And before you fall asleep with all the legalese, what's a contract? What's a popular type of contract? Well, think beneficiary designations or trusts. Most of you, when filling out your retirement paperwork or life insurance paperwork, are asked to provide a beneficiary. You fill out the beneficiary designation. That is the contract that you have with the insurance company or your financial institution as to who is going to receive those assets when you pass away. The second way that assets pass at death is through operation of law. Operation of law sounds very legalistic, but what does it mean? It's really co-ownership with survivorship rights. The most common examples are bank accounts. Often those are set up joint with rights of survivorship, or maybe real estate, which is also commonly set up as joint with rights of survivorship. What that simply means is when one co-owner passes away, the ownership will automatically pass to the surviving owner. The last way that assets pass at death is through probate. Probate is really the catch-all for all those assets that don't pass outside of probate through operation of law or beneficiary designations and contracts that I discussed earlier. Probate is for those assets that are in your name individually with no beneficiary designated. For those assets, a probate estate is opened in your local probate court, and your last will and testament is admitted to the probate court. What's the last will and testament? It's basically the instructions to the court and the executor of your estate as to who will receive those assets. The important thing to understand, though, is the last will and testament is only going to control the distribution of the assets in your probate estate. It has no bearing on those assets passing outside of probate through beneficiary designations or survivorship rights and co-ownership. You're probably wondering to yourself, what types of assets are covered by beneficiary designations? Well, here are the three most popular types of assets. The first and probably the most popular is with retirement accounts. Think your retirement account at your employer, your 401k, your 403b, 457, and I could go on and on. There's also IRAs. You have a traditional IRA, inherited IRA, Roth IRAs. Those are all retirement accounts on which you can designate who will receive that property following your death. The second popular vehicle for which beneficiary designations apply is life insurance. Often when you fill out that life insurance application, you will designate who is going to be the beneficiary to receive the proceeds of that policy when you would pass away. The final asset to which beneficiary designations apply is annuities. There's a variety of annuities out there, TSAs, the qualified, non-qualified. They're all different types of annuities, but they are all contracts, meaning a beneficiary designation will be filled out with the insurance company or issuing financial institution, specifying who's going to receive that property, that asset when you pass away. Of those three assets, by far the most popular asset used in plan giving is retirement accounts. The reason for that is, well, I can't give it away. That's going to be a topic of a future video. But in short, no tax is ever paid on a retirement account that is left to a charity. As beneficiary designations have grown in popularity, I want you to know how simple and convenient it is to set up a beneficiary designation and make a planned gift to the foundation. Here's how it works. First, you need to visit your financial institution's website. Under Forms, you will typically find a form entitled Change of Beneficiary Designation or something similar. The second step is to complete the form. This will include providing personal information such as your name and address, but most importantly, you will need to provide the name of the foundation as your beneficiary. The final step is to return the completed and signed form to your financial institution. Please note that if you work with a financial advisor, they will be able to assist you as you work through this process. Most importantly, updating your beneficiary designation is simple and convenient. It does not require updating your will or your trust agreement. Now that you understand the basics of beneficiary designations, I'd like to offer a few tips for identifying donor prospects who might be interested in making a planned gift through a beneficiary designation. The first type of donor is a donor who already gives to the foundation out of their IRA using a qualified charitable distribution. For that matter, any donor that has a retirement account can make a planned gift. The final type of donor is a donor that is looking to make any type of a legacy gift. As I mentioned earlier, beneficiary designations are convenient and easy, much easier than updating your last will and testament or trust agreement. Before we wrap up, I'd like to go back to our earlier question about Susie Donor and her beloved dog Fido. Did Fido really receive that $5 million IRA? The answer is yes. He was the beneficiary. Had Susie Donor updated her beneficiary designation at the same time she updated her will to designate the foundation as the beneficiary of the IRA, that $5 million would have gone to support the causes that she was most passionate about. Thank you for watching today's video. Hopefully, we've been able to remove the mystery around beneficiary designations. Just remember, planned giving does not need to be complicated.